I'm Henry Quillian here at Taylor English Numa. I've got about 10 colleagues in the room with me and about 10 colleagues on virtually. Today's topic will be getting evidence before the time normal discovery starts by taking preservation of evidence depositions. For those of you that watch this on video or out there in the world, this is a discussion of things I've observed, and also in particular a discussion of the civil rules of civil procedure in Georgia. And I've got a little add-on of the federal rules of civil procedure. Just remember that you need to rely on your own counsel, or if you're a lawyer, rely on your own research and figuring out what to do, especially in your particular jurisdiction, wherever you may be trying to pursue evidence. So the topic today is trying to get basically an effective remedy for your client. And part of if you're in a lawsuit, what are the two fundamental things you need in order to win a lawsuit?
Law in your favor and facts in your favor.
All right, law in your favor and facts in your favor. And what can taking a deposition do for you? Does that solve the law problem?
Nope.
No. But what does it solve, potentially?
Facts.
Getting the evidence. And what do old people, when they get really, really old, tend to do?
Die,
okay. And then what do, let's say, I've got some responses from my partner in construction litigation, Mark Carter. What do contractor employees tend to do as soon as the project is over?
Leave. And
they can be here today, they can be in Alaska tomorrow, right? What do people on a ship that's at port tend to do? They tend to take off, go on a voyage, right? And similarly, military people, sometimes they're here physically one day and they're somewhere else physically the next. So all these people are likely to come, and they're likely to be needed for some evidence and some litigation during the course of your practice. And so the question is, if you don't have a lawsuit pending and you can't just run out and tag the person with a subpoena before they leave, or before they die, or before they go on a voyage, how do you get this deposition so you can preserve it and utilize it in the future for your case? So it turns out I've done this a number of times during the course of my career, and it's not always easy, but it always makes an impression if you succeed. I guess I'll put it that way. I've had nearly dead people, I guess, that I've deposed. I've had people that I knew were going to be leaving the territory, for lack of a better description, that I needed to depose. And then I've had people on ships that I knew were about to sail that I had to depose. Those are the ones that come to mind right now. So let's figure out how you do this under the Georgia Rules of Civil Procedure, which is called the Civil Practice Act, and then see whether there's any similar remedy under the Federal Civil Procedure. Does anybody know what code section in Georgia courts of record controls depositions? All right.
9/11/30.
9/11/30. Okay. That is the core deposition code section. And then you have 9/11/26, which is the overall discovery control section. When does discovery start in a normal, everyday lawsuit in Georgia once you've served the defendant with the lawsuit?
After service of the defendant.
Okay, after service of the defendant. So when does it start? So it does not start any earlier than the service of the defendant, typically, right?
Right.
Thank you, Winnie. And so that 30 days, which is the time that it might, let's say 10 to 15 days, whatever it is, up to 30 days, that you're not going to have the availability of discovery. So what do you do if you've got somebody who's, and we actually have a case like this, potentially on the deathbed, has very relevant testimony. You want to get a lawsuit going, get that person served, hopefully get the defendant served, hopefully get the person prepared for and at a deposition for preservation of testimony. How do you do that? Because you just don't know when somebody's going to pass away, and of course that's gotten even more prevalent in the last couple of years, where people will get sick unexpectedly, sometimes from a novel coronavirus, and will be unavailable to testify, could pass away. So if you go to 911 OCGA 91130, the general rules are that you can serve a notice of deposition, and that deposition cannot be taken prior to the expiration of 30 days after service of the complaint, unless a defendant serves discovery on the plaintiff. But if you've got to get a deposition done extremely rapidly, then you can look at 91130B2, which is entitled Special Notice. And this is a procedure you can do without a leave of court in order to get opponent under oath in a lawsuit that's already been started by commencement of the filing of the complaint and service of the defendant. Why would leave of court be a problem if you had to have leave of court in order to take a deposition?
You don't know when you're going to get a ruling.
That's right. You don't know when you're getting a ruling on the request for the leave of court. Some judges, you might be lucky you get it the next day. Some judges, you might get it 3 months down the road, and that may be way too late. So leave of court, for those of you that don't know, is getting an order from a court permitting you to do something that's otherwise not permitted as a matter of right. So it's really getting, rather than saying leave of court, it's really getting an order saying you can do it. So let's look at 91130B2, which I will say, y'all will know as much about this as anybody in the world once you go through this session, because there are 0 cases citing 91130B2, zero commentaries that at least come up on LexisNexis citing 91130B2. The only thing that came up when I searched was a sample notice of deposition on Lexis. Amazingly, you got the code section, sample notice, no commentaries, no cases, no. I guess it's because by the time it either happens or doesn't happen, it's a done deal. There's no real rulings or whatever to be made by a judge, so there therefore no appeals, no appellate decisions, etc. Okay, talks about the general requirements in 91130B, the general requirements for a notice of deposition. We won't go into those. Basically, it's sending a notice of deposition in accordance with the normal things, that identifying the place, the time, the party to be deposed, the means of transcription, etc. And then a special notice. It says, leave of court is not required for the taking of a deposition by plaintiff if the notice, and then subsection A, states that the person to be examined is about to go out of the country where the action is pending, the county where the action is pending, and more than 150 miles from the place of trial. So that's 2 different criteria there that have to be satisfied. Or is about to go out of the United States, that would be out of the country, or is bound on a voyage to sea, and then it's comma, and will be unavailable for examination unless the deposition is taken before the expiration of 30 the 30-day period. 30-day period responds back up to the 30 days after service of the summons and complaint. So the way I've seen this read is that normally if 30 days has already expired, then you can take the deposition anytime you want. But if under these special circumstances, you can take it earlier. And then the subsection B has the requirements for the special notice. It sets forth the facts to support the statement. The plaintiff's attorney shall sign the notice, which is normal, and said attorney's signature constitutes a certification by him or her, to the best of his or her knowledge, information, and belief. The statement and supporting facts are true. So effectively, it's giving an affidavit, but since you're an officer of the court, it's a certification. If a party shows that when he or she was served with the notice under this paragraph, now here a party, who is a party other than the plaintiff?
Defendant.
The defendant, the other party, yeah. If a party shows that when he or she was served with the notice under the paragraph, he or she was unable through exercise of diligence to obtain counsel to represent him or her at the taking of the deposition may not be used against such party. So what does that mean if you're suing average Joe and you want to take a deposition where the testimony will be used against the average Joe?
Got to make sure he has an attorney.
Yeah, that person can come in and debilitate, for lack of a better description, your deposition by saying, I couldn't get an attorney. What if you're serving and suing an insurance company? What's the likelihood of an insurance company succeeding if you give a reasonable amount of time in getting an attorney? I see people shaking heads. What's the deal?
Yeah, they'll have counsel.
Okay, yeah. If an insurance company can't get a hold of an attorney within a reasonable period of time, then something's wrong with that insurance company, right? They're doing what insurance companies do, I guess. So let me ask you this. But how does that drive when the time of the deposition should be set? This debilitation subparagraph. It pretty much means you better not set the deposition the day after the service of the complaint and the notice of deposition, right? Which you would want to draft up your notice of deposition to go with the service of the summons and complaint. And then you would want to give a reasonable amount of time for that party to get an attorney, and it just depends on what you think the capability of that party would be to actually obtain an attorney. So, and if it's an uninsured claim against an individual, unfortunately, that could mean, a long time or never before the deposition actually takes place. So if you think the person is actually going to leave, which you have to believe if you're certifying, then would you go ahead and take the deposition anyway, or do you just not take it and leave the testimony untaken and let the person leave?
So what it is, probably just take it.
Yeah, I would take it anyway and let the other side argue they couldn't get an attorney, because they actually have a showing they have to make.
Yeah.
It has to be they have to show the exercise of reasonable diligence. If they can't show that they never even called an attorney, never looked at the phone book, never asked a friend who I might hire as an attorney, then you might be able to use the deposition. Okay, so what is missing from the special notice 2A that allows the deposition to take with leave of court not being required? What bad circumstance of the need for an early deposition seems to be missing?
There's no reference to a person dying.
There's no reference to a person dying when he says. And that's like the ultimate voyage at sea, right?
Right.
So, but unfortunately, they don't have that listed. So, under the circumstances, that of that scenario, what might be an additional way, taking the course of action that you could use to try to pin down testimony as soon as you can possibly get it. If leave of court is not required under the circumstances listed, which is out of the county and 150 miles from trial, or about to go out of the United States, or is bound for a voyage at sea, what would be the safest way to go if you can get it for taking somebody dying?
I'll just use that last part of that sentence, will be unavailable for examination unless the deposition is taken before the expiration of 30-day period.
Okay, so you argue that, you would argue it to whom? You would get leave of court, right?
Yes.
So maybe there's a way you could manage your bets. You could file with your complaint, summons and complaint, an emergency motion for leave of court, take a deposition early, along with a special notice, probably supported by, since it's a petition or request for an order, supported by an affidavit. Use a notice that has the same facts set forth in it. Obviously, it would not set forth one of these other things if the person wasn't leaving the county or wasn't going on a voyage or wasn't leaving the United States, although I think you could argue that dying is about to go to the United States. And basically do everything you can to try to get it nailed down. Maybe give it, notice your deposition a bit further out than you might prefer, to try to see if you can get an order of a court caught. And then if you did file such a motion with the complaint and you really thought that this person's in grave danger of passing away, but they had very important testimony, who would you call and after you filed the notice, the motion, the complaint and the summons and gotten the civil action number?
Judge's clerk.
The judge's clerk. Why? Because they are the gateway to the judge.
The other, can I add as a practical matter, especially as I add and you just stop, as a practical matter, after COVID, I know for a fact that there are courts, including Cobb County, that have taken the position because they are still backed up with family law and criminal law cases, that they do not get any notices of anything in civil cases. And they have taken the position that if the litigants in a civil case want something before the court, that they will call the clerk and schedule it. So, when I was a baby attorney, I was very scared to call a judge's chambers. But don't be afraid to call them up and say, we need a hearing on this. And if it's this important, I would probably take the extra step to go get the stamped copy of the complaint, make copies of it, take it to the judge's clerk, ask for a meeting with the counter clerk or the legal assistant, whoever, and get a rule nisi and get it heard. It could be ex parte right then it could be for this. You might get it the same day, but you really have to be proactive, because otherwise, if you just file it, there's a real good chance the court will never see it.
And that's we've noticed that in Gwinnett County as well. The way to get something on the docket is to call, get in the rule nisi, get it entered, basically showing. There's hardly anything that substitutes for showing up in person. If you're standing in front of somebody's desk with let's say you have to have a mask on, but you're standing there and saying, I really need to get something done. People have a tendency to want to help lawyers help their clients. The court is there to do its best to provide the services it can. But I think what I hear you saying is maybe they don't even they must load the things into the docket, but don't send a.
Yeah, every county's system is different. Some of the smaller counties are still everything, handwritten and not as much electronic. But I know there are counties that have just turned off any notification system regarding civil matters.
Okay.
So it doesn't get in the way of the quote unquote more important family and criminal law matters they're still trying to clear up.
Okay, so that holds true of actually getting a motion set for a hearing.
Yep, that's it. That's everything in these courts.
For a status conference.
Motion for summary judgment, status conference, motion to dismiss, discovery motion, anything.
So that raises another practical point, which is even though some courts, especially federal courts, will publish a standing order that says, hey, if you have a discovery dispute, we want to hear from you in a 2-paragraph maximum email first before you file a motion to compel or anything of that nature. A lot of courts that don't have that rule still would love to hear from you in a 2-paragraph email directed to the law clerk saying, hey, we've got a discovery dispute. Can we have a conference instead of filing a formal motion? And we actually had one, for better or for worse, recently where we did that, and essentially the judge ruled against us, but that was okay because it resolved the issue. It saved the client thousands of dollars. The only question was, could the opposing party who had let discovery expire notice a deposition after the close of discovery and get a deposition from our client? The judge ruled, yes, you can have the deposition, but the other side has to give the deposition too, and it has to be within this limited time frame. So essentially, the judge said, what's good for the goose is good for the gander, and then ordered a specific time frame for the deposition. So, but basically, it probably saved between the two parties $3,000 worth of legal fees to just get that matter resolved. It's no big deal to go get the depositions taken. Okay. So you now have 91130B2 as an option. You have a motion for, or I would call it emergency petition for early setting of a deposition of a dying person, or whatever. You go ahead and put in the title of the motion, the urgency of the matter. I would put a fact in. You're going to have a fact in your notice and everything anyway, and facts to support your motion. So you might as well go ahead and say what it is, so that there's no question that there's urgency. So I looked quickly to see whether there was a rough equivalent or an equivalent under the federal rules, because the federal rules actually don't allow you to start discovery until you've done what? Yeah, a Rule 26F conference. Yeah, so and so that's a significant time after the filing of the complaint, the service of the complaint upon the defendant. So I plugged into the trusty Google web search and deposition to perpetuate testimony, and it's not that hard to find. Rule 27 of the Federal Rules of Civil Procedure lays out a 2-page procedure by which you can get notice of a deposition earlier than you would otherwise. And however, you have to file a petition. You have to set a hearing on the petition with the court. You have to lay out the facts that would be necessary to get the testimony. And by the way, the interesting thing about this is this can be filed in any district court, and there doesn't have to be a pending lawsuit. Essentially, what you do is you say, this person has testimony that will be important to me in a lawsuit I anticipate participating in, that will be a valid cause of action in the United States. And I need to get this person's testimony now, because let's see what the options they give here are with as the basis. They are It's really the only requirements are that the petitioner expects to be a party to an action cognizable in the United States court, but cannot presently bring it or cause action to be brought. So that could be a situation where there's some statutory prerequisite to bringing it, where the matter isn't fully ripe yet, I suppose, or something of that nature. The subject matter of the expected action and the petitioner's interest in it, the facts the petitioner wants to establish by the proposed testimony and the reasons to perpetuate it, the names and descriptions of the persons whose the petitioner expects to be adverse parties and their addresses, so far as known, the name and address of the expected substance of the testimony. And then it says at least 21 days before the hearing date, the petitioner must serve each expected adverse party with a copy of the petition and notice stating the time and place of the hearing. So what I'm thinking that in the maritime case I had, where a ship ran into a big pier and the ship was just unloading and reloading and it was going to leave, I took a bunch of depositions of people on the ship, knowing that they were going to be on the other side of the world, but I didn't actually line up all the testimony. I just went and took the depositions, but I knew that something must be available in the federal rules to allow this, because I went and took a ton of depositions actually very shortly after the commencement of actually the incident that occurred. And so there's also one other factor, which is under 91130, and I feel certain under Rule 27, if you can get the opposing side to stipulate to allow the deposition, then and basically get waivers of any objections in advance to the actual taking of the deposition and getting the testimony, then that'll also provide a means for accomplishing it. So that's my presentation. Anybody have any further discussion? When are you prepared to do this? I will only say that this is a way to, if you want to really make an impression on the defendant, taking a deposition like right out of the box and having it go really well can set the tone for a case. So thank y'all for being here. Sorry we had to start late. I was having to successfully pursue my property tax appeal, and y'all have a great month. Take care.